Is this thing on? Oh, this one's dead. There it is. There it is. Our next speaker is Priscilla Healy. Priscilla's with, no, is this on or off? Can you hear me? Fine. It's off.
This is on.
This one's making noise. There it is. With the Ontario Securities Commission. Priscilla spent 4 years in the corporate finance area and is now working with the new proposed act, as I understand it, and is going to bring us some insight on dealing with the Ontario Securities Commission. Priscilla?
Thank you, Steve. My mission in being here this afternoon and today, just by sitting here, is to try to establish the point that the Securities Commission is accessible. I think that the Securities Bar, which is a fairly close-knit and definable branch of the bar in Toronto, knows that the Securities Commission is accessible, and they know how to use it, how to use the staff, how to use the Commission in the interests of themselves and their clients. People who aren't the Securities Bar usually don't know that, and I would like you to come away with the message that if you have a problem, please don't be reluctant to contact us, and you may find there's more help than you think, and you may find you can sleep better at night, and you have protected your client better by coming in. When I spoke to, I mentioned the fact I was going to speak to the general practitioners from the Commission. The Deputy Director of Enforcement at the Securities Commission expressed his view that dealing with us is like a game of snakes and ladders. And I think that's very true in many ways. And again, the Securities Bar knows the ladders. They know the shortcuts, and what they most know is who to talk to achieve the result that they want. And my paper and the schedules attached have tried to tell you exactly who to talk to when you have a problem or a question. The snakes that are involved are difficult to avoid, and all you can do is try to minimize them. One of the chief snakes, I think, is timing. You just never know when your inquiry may not be answered, or your formal application may not be answered promptly enough for your purposes because of a number of reasons. The happiest one would be that the staff is very busy. The unhappy ones are that there's a perception there's a serious policy issue involved, and the Commission itself, as opposed to the staff, has to deal with it, and it just takes forever for them to do that. I've had we've had applications sitting around for a year because while waiting for some sort of overall policy consideration. However, that should never happen to you, and don't let it. It does not have to happen. If you push, your applications will not sit very long. Force them to a conclusion. The game of snakes and ladders is a game, as I say, I think you should play. I think you should join it and use us to your advantage, and use the Securities Act and the policies and the discretion and the flexibility, which is enormous, to your advantage. You are not bound by the letter of the law unless you choose to be. And you can choose to be by not trying to get any discretion in your favor. I want to make a point, just an introductory point. I'm speaking, of course, from the staff of the Commission, and you must appreciate that the staff is a separate entity, although we occupy the same office quarters as the Commission itself. And the Commission is the judicial body, and it's the legislative body. The staff is the administrative section. There's a lot of discretion in staff, but when ultimately, if you are not satisfied with the result that you have a right of appeal to the judicial body, which is one reason for not involving them too soon in the process, so that you haven't thrown away your right of appeal. As the people have been, my colleagues have been indicating, there is a great deal more to securities law than the statute and the regulations, and they have all told you the various areas you have to look at. I'm not sure if anyone has stressed blanket rulings, class rulings, Every now and then, the Securities Commission considers that there is enough precedent or is there enough good reason to give an overall exemption from the Act to a class of issuers. Securities law evolves. It is made by policy statement, which don't have the force of law, but they do in practice because it's so difficult to get around them. Blanket rulings, refusals to make a ruling, and that's something that you will never know what applications were made and were refused. You won't know unless you inquire. I can think of a recent case. There was a chain of exemptions to do with guaranteed debt securities. That a couple of rulings were given, and it would give the practitioners the feeling that this happy train of exemptions and orders might be extended indefinitely. Well, there came a point when there was a hearing and the applicant was refused. That hasn't been published. If it's published, it may never be published in a way that it's clear what happened and why. And that is why you need to speak to people at the Securities Commission, speak to the staff who will know and who will tell you. So you know where the thinking is, you know how far you can go. The staff will know of precedent prospectuses, for example, that might be a help. And I hope that if you're not going to specialize in securities law, you won't do too many prospectuses because it's very time-consuming and a highly specialized business, although it's certainly very interesting. By all means, start if you want to get into that business, but it's tough. At any rate, besides blanket rulings, precedent rulings that are quite important because they've been the subject of hearings, interpretation notes are published. There have been one or two, and one of them is very significant. It has to do whether a trade is a distribution in Ontario at all, and so caught by the Act. It's Interpretation Note 1. I don't think you can stay on top of the developments in securities law unless you practice in the area, or you're a super person if you're a general practitioner. So that what I am suggesting to you is that you develop some contacts. You have a basic understanding of where to look, and you try to do your homework and develop some contacts, and you will find it much easier for you. Another area that's fraught with pitfalls has to do with the management of the Securities Commission, in that it changes every 2 years and with the new chairman, and two and a half years, and practice and precedent that have built up with the commission under one chairman might alter quite radically, not perhaps immediately, but there'll be a development with the next chairman. In the jurisdiction of the predecessor to the present chairman, the buzzword was, there were two really, integrity of the market, integrity of the closed system, and nothing could be done that would threaten the integrity of the market or the integrity of the closed system. We have developed or changed since then, and the buzzword now is efficiency of the market. Now you compare efficiency of the market and integrity of the market, and I'm not quite sure where that gets you, but we are certainly into efficiency. I won't say we're out of integrity, but we're we're highly into efficiency. And you can, if you know this sort of thing, which the securities bar knows, you can use it to your advantage. And then if you are presenting an argument before the commission or to the staff, then you stress efficiency. You certainly don't stress integrity of the closed system, because the closed system has been shot full of holes in the past year, and with the amendments that have been proposed, it's a new closed system. It's greatly modified. So as I say, you know who perhaps to talk to, develop some contacts, and you will have an idea of what is the useful approach. The Securities Commission and the staff would rather practice preventive medicine than enforcement procedures. So it's much better to find out in advance rather than making an error. The second main point, I have said that the Commission is accessible. The second main point I would like to make is a point that I think probably applies to most administrative agencies, except that I don't really have an intimate experience with them. But it is very true of the Securities Commission, and that it is a people place, in that you are not dealing, or you shouldn't put yourself in the position of dealing with a nameless civil servant who's a cog in a vast machine. You should find out who you're dealing with and deal with them on a relatively individual or personal level. The people you're dealing with, you should know you've got client pressures and time pressures, money pressures, and the staff of the Commission really aren't interested in leaving a matter to molder on their desks for a year. They want to get it in and out and resolved satisfactorily, and they will help you do that. It's to both sides' advantage to do that. The person you're dealing with, you have to recognize, may not, unfortunately, have authority for a decision. So there may be a time period while they check with the various levels of the bureaucratic authority, which is necessary because you don't want to be confronted with civil servants on an individual level with a great deal of discretion, which might be translated into whimsy. So there is a careful supervision and bureaucratic process, which sometimes is a little slow. Most of the staff of the Commission, I think you should know, are proud of the Commission as a government agency, and that's a factor in dealing with them. You should know that you may be dealing with a new employee. You may be dealing with a person that's there on contract who may themselves be a very good securities lawyer but may not have been there for very long, so that although they may have a good grasp of the law, they may not have a good grasp of precedent and practice. And find out if you detect some uncertainty, although usually the person you're dealing with themselves will refer questions if they have any doubt as to the answer. But just be aware that there are different kinds of people in different sections in the Commission. You should also know that we talk to each other. We talk to each other about problems. We talk to each other regularly. Certainly the lawyers do, and in fact everybody does informally. The lawyers do quite formally as well as informally. And therefore common problems will be aired and common solutions arrived at, and there isn't too much point in shopping for favorable answers. The last point about the personnel is that we prefer to negotiate rather than confront, and you will get further in a negotiating stance, I think. You certainly always have the option of adopting a litigious or a confrontational approach. It does tend to slow things up, and I think probably the only time when that's appropriate is when you're dealing with a serious enforcement matter, when your client has indeed been in breach of the Securities Act, and then you have to take a criminal law stance as far as dealing with the Commission. You may not want to bare your soul. But if you're dealing with in a commercial context, discussion and negotiation will be much to your advantage. My best recommendation to you here, is to find someone or several people at the Commission, and I think it's always easier for lawyers to deal with lawyers, with whom you have some sort of rapport, and call them up when you have a problem. Not that they may be able to solve the problem, but if the Securities Commission can help, they may be able to refer you right to the specific person who can deal with the question, and that will save you from trying to explain at length your problem to the switchboard operator, who find it a lot more difficult to allocate the inquiry to the appropriate person. If you're making an inquiry, I have stressed how helpful we are. You do, however, have to do your side of the job. You have to do your homework. You have to go as far with the law as you are able, and you have to tell us the facts, and you have to be perfectly straightforward. If you get a reputation, and as I say, we talk to each other, and if someone gets a reputation as not being straightforward with the facts, they will find their relationship with the Commission considerably less satisfactory, as you can imagine. Be as helpful as possible. If you're sending up documents, send up copies. Don't assume that because it's on Commission file and we already have it, it's accessible. It is not, I will tell you. We have to read microfiche as well, and maybe I come from the, well, obviously from the pre-television era. I feel very ancient, but I do not like reading microfiche. I like reading hard copies, and it's much easier if you send up hard copies of your documents. Whatever you do, don't fail to follow up. Don't assume that because you have put your application or your formal inquiry into the system that in due time an answer will emerge. It will emerge in time, but the time may not be very due. So do follow up with your matter and get yourself placed on the priority list instead of the, well, they're not calling today with their inquiry, so I will do something else. You know yourself in your own practice, that's how one operates, so be aware that we do as well to some extent, although we try to prioritize matters in terms of the way they come in. Obviously, crisis situations arise. I said I was only going to be half an hour, didn't I? I won't say very much more. What you should not ask for is legal opinions from staff, because we will not give them, particularly over the telephone, any more than you would give a legal opinion over the telephone. Don't ask us who is the public. My own view is that you have to do your own research, you have to look at the facts, and my own approach to that is if you think the person will sue you, if the transaction turns sour, that person is probably the public. So it's not an unhelpful practical thought, because your problems with the Securities Act, although there are possible enforcement provisions that can be brought and are brought, your bringing enforcement action is discretionary as well because of priorities. Your more dangerous exposure is to the civil liability, rights of rescission and damages, in my view. And when we have class actions in Ontario, the exposure there will increase tremendously. Don't come with schemes of technical compliance that contravene the spirit of the Act and expect to be received with applause. I mean, those are just unanswerable. If you can technically comply with the Act and it's against the spirit, anything might happen or nothing might happen. If you have them, keep them to yourself and preferably don't do them. Comply with the spirit of the Act and you will be comfortable and you will sleep nights and you have protected your client. We can't give you help in designing a transaction, although we might, if we just happen to have seen a recent one that fitted your facts. The Commission will not give, as a general rule, retroactive rulings to cure past transactions. And the staff will never recommend them, or very, very seldom. And the reason for that is the Commission and the staff are very hesitant to, they're not hesitant to say we won't take any enforcement action against you. They are hesitant to prejudice the rights of an investor that may have arisen. What you can ask, and what you should ask, if you have any problems, is ask for staff's view of the transaction, the legality of a transaction. You can discuss things with them. You can ask for precedent rulings or decisions. You can ask what the thinking, the climate of thought is at the Commission at the time. You can certainly ask, and you should ask, what the chances are of success of an application for an exemption. The staff will tell you quite honestly whether they will recommend it, whether the staff will, and what they think the Commission will do. if they have any feeling at all for the matter. And the staff and the commission are distinct, and what the commission will do may not be what the staff would recommend, and vice versa. So the staff, however, will make you aware of that. They will also tell you the avenues of appeal. If you ask, and if you get an answer that you're not happy with on a formal matter or an informal matter, and you're not sure what to do next, ask, and you will be told, and don't be hesitant to ask. It's not appropriate, I don't think, to jump people's heads. You don't like it to be done to yourself, and I don't think the staff likes it, but you are entitled to a certain extent, giving due warning and go up as far up the line as is necessary. I'm only concerned with people who start at the top, and then there's nowhere to go. It's been as an appeal, because a number of the decisions of the commissions are no right of appeal anywhere, at least the ones to do with the registration and prospectus exemptions. So I have a considerable more I could say. You're aware that the staff and the commission have a great deal of discretion. I would urge you to use the commission for yourself and for your client. Even if you've made an error, come in. You do have to come to grips with errors, and they're easy to make in the securities area. It's very complex and very pervasive, and get the situation resolved, and I have told you who to speak to in my paper. And it will be much better for everybody if when you find a problem situation, you deal with it. And you will find help and not a great deal of criticism, because general practitioners are permitted to make mistakes. The securities bar are not. Okay, thank you.
Dare we answer? Yeah, that's right. I'm not the securities bar, so I can try to answer the questions. Can I just take? We have there's a couple questions here, and perhaps we'd ask if you have any. We'll take a few minutes to do that. First, for Frank here, is a question: can you be exempt from the registration but not exempt from a prospectus? I.e., is it possible to not be trading but still be distributing?
Excuse me, if I understand the question, the way I've always thought about it is that every distribution involves a trade, but not every trade is a distribution. And I think the questioner is getting to the first part of that. The way distribution is defined in Clause 11 of subsection 1, I think each of the four branches begins with a trade by an issuer, a trade by an issuer, a trade by a control person. And then when you get into the second level of the closed system, for your next level of distributions, it always talks about the first trade. So my reaction to the question is that a distribution must involve a trade. But it's, on the other side of the coin, it's important to appreciate that not each and every trade will be a distribution.
The next question's a little lengthy, and Jean, you've had a chance to consider it, so do you want to perhaps read it and then perhaps answer it?
The question is, if a subscription agreement contains conditions, when does the distribution occur? When the subscription is signed, or when the conditions are met, i.e., when do you file Form 20? Can you impose an escrow pending satisfaction of the conditions and thereby extend the date of the quote-unquote distribution? I guess technically your distribution occurs perhaps even before you've signed the subscription agreement, because a distribution is defined as a trade, among other things, a trade in securities of an issuer that have not been previously issued. And as you know, trade includes anything done in furtherance of a trade. So conceivably, I guess you could be distributing the minute you do anything in furtherance of obtaining that subscription. As a practical matter, I don't think any of us file our Form 20s until after the private placement is done, i.e. we view the 10-day period to run from the date of closing, i.e. the date of sale. And as far as I know, the commission has no adverse view of that practice. The second aspect of that question is, can you impose an escrow pending satisfaction of the conditions and thereby extend the date of quote, distribution? Given that I think technically your distribution occurs when at the moment you do anything in furtherance of the trade constituted by the subscription. I don't think you extend the date of distribution. As to whether or not you can impose an escrow pending satisfaction of the conditions, I think the answer to that is yes. It's just a contractual matter, and to the extent you can make your business deal on the basis that money is put up and held in escrow, securities are issued and held in escrow pending satisfaction of certain conditions. I don't see any legal reason why you can't do it. As a practical matter, it seems unlikely, but I think legally, yes, it can be done. I don't want to keep you, I know everybody's dying to get out of here, but I just wanted to make two remarks that arise out of remarks that were made after I spoke. I spoke slightly out of turn with Frank coming after me instead of before. Frank went through what I call the private placement exemptions, and what I wanted to make clear was that a private placement can be done pursuant to those exemptions whether or not your issuer is a reporting issuer. None of those exemptions rely on the issuer being a reporting issuer. The problem comes up on resale, because unless your issuer is a reporting issuer, you never get out of the closed system, i.e. all resales have to be done. If your issuer is not a reporting issuer, all resales will have to be made pursuant to an exemption. It won't be enough that you satisfy the hold period, because the two branches of the resale restriction that gets you out of the closed system are that your issuer is a reporting issuer, and secondly, that you comply with the hold period. So if your issuer is not a reporting issuer, you are always, all your trades are rolling around inside the closed system. The second thing I thought I might mention is both Frank and Priscilla referred to the sort of body of jurisprudence that and statutory and regulatory provisions that relate to securities practice. And obviously there's the Act, the regulations, the policies, the blanket orders, which Priscilla referred to. The way you keep these things up to date is that the OSC produces, it's weekly, I believe, isn't it your bulletin? A weekly bulletin in which all blanket orders and rulings are published, and all policies and interim policies are also announced. And so if you subscribe to that, you just, those of us who do a lot of securities just maintain basically a manual in which you file that material. Unfortunately, the rulings and decisions that are made by the commissions, while they are reported, are at least not publicly indexed anywhere. So it's not like, you know, there's no equivalent to the patent law reporter or the family law reporter or the business law reports where you can look up the jurisprudence that has been developed by commission decisions over the years. It's at the moment the best way, unless you really know the cases, is to phone the staff. Yeah, the text. Oh yeah, well yeah, that's right. I mean, there are people like Al Buini have put out very helpful textbooks, but they go out of date very quickly because these characters are making decisions every week. Somebody will do the securities bar a great favor someday and produce a proper reporter of the securities law decisions, but to date it hasn't been done.
Mr. Albuini is one of my partners, and I can tell you that many of them are at work on just such a little volume for everyone. It's going to be a loose leaf update of his book. Are there any questions that we can answer for a few minutes?
I understand that you do SRTC by way of promissory note over $50,000 when you have to use an operating plan. Has that changed to any degree by the policy that was mentioned that Mr. Mason has securities?
The question was whether or not you on some of these SRTC deals, whether or not the $50,000.
I understand you do without an offering memorandum, where they should policy, the person today, it doesn't change that.
I can take that one if you want.
Go ahead.
I think those types of transactions probably made on reliance on the exemption for the securities themselves under Clause 4 of 34 sub 2, which is a negotiable promissory note, and if it's to an individual, it's not less than $50,000. I think that exemption would still be applicable. I mean, as long as you're talking about a negotiable promissory note, you have that exemption. And in addition, you had the possibility of designating it as a government incentive security and complying with 14G, or since it was designated, using 14G as a alternative prospectus and registration exemption.
The other thing to remember too is you don't necessarily have to fall into, and I know it's been said over and over, but you don't necessarily have to fall into the offering memorandum. It's for example, the 71(1)D, the $97,000 exemption. If you're going to rely upon that and don't give anybody a document, don't give them anything, or give them those things that are specifically exempted by virtue of the regulation, current financial information, then you're not even into the problem of an offering memorandum at all, and don't give it. The problem comes, you slip into it accidentally because you've given somebody something which by definition describes the business and affairs of the issuer, and bang, you've got yourself an offering memorandum and have to comply. The same thing happens with respect to, and watch the wording of the Act from time to time. Some of the restrictions talk about no steps taken to groom the market, some talk about no advertisement. You got to be careful that if you're going to make advertisements, you get caught as well in terms of the information that has to be given. I would always take the view of try and stay away from an offering memorandum with the information you're giving if you can, and the Act doesn't say here's when you have to give one. It says if you gave something that looked like this or close to this, you have given an offering memorandum, and therefore certain results flow.
The only circumstance in which you have to give an offering memorandum is where you are seeking to rely on the government incentive security exemption or the $97,000 exemption and your advertising. I think the point that should be made about the government incentive securities is just because there is an exemption for government incentive securities that mandates an offering memorandum doesn't mean that in a placement of government incentive securities you can't rely on another exemption if you bring yourself within it. For instance, if the aggregate price being paid by an investor is $97,000 or more and you don't advertise, you're off and running on that exemption and no offering memorandum need to be given at all.
I'd like to echo that comment, actually, that you do get the right to choose your exemption. I find commonly that people automatically sign up for 71(1)D, which leads you into filings of Form 20 and 71(4) hold periods for your security. But frequently, for example, on an exempt takeover bid, just look at Section 71K, and you've got an exemption there, and you've also got the 71(5) exit from the closed system, no hold period, just net reporting issuer having been a reporting issuer for 12 months. So choose with care your exemption, understand the consequences before you shoot off a Form 20 showing you've accepted 71(1)D.
Yeah.
One other practical question for Ms. Healy. Are there any other changes to that list of commission personnel following Mr. Pescudo's appointment as director?
No, not at the moment. I expect there will be shortly. And they'll be published, I presume when they're settled, they'll be published in the bulletin, probably, well, in the OSC bulletin in any event. I'm sorry, I should have called your attention to something. Thank you for bringing that to my attention. We have a director, a new director, who is the head of staff of the Securities Commission, and that is Hermano Pescudo, who is on my list dated October 1, is shown as the legal advisor, and he is now the director.
There are a couple, Priscilla might just comment, there are a couple of senior legal positions to be filled too, aren't there?
Yes.
Isn't there, that are still to come up?
Yes.
Counsel is one, and
Then the legal advisor.
legal advisor. These are newly created positions to advise the chairman and so on. Plus, as we commented as well, the current chairman's mandate or his position expires. When is it? The end of the year?
As far as anyone knows, it will expire at the end of the year.
Peter Day's term is up at the end of the year, and I don't know what's going to happen then. Well, if that's it, we'll carry on. If anybody wants to come up after and ask any questions, we'll be here for a moment, but otherwise, enjoy the rest of the afternoon.